Well, good morning, everyone, and welcome to this webinar brought to you jointly by Cornerstone Barristers and Browne Jacobson. I'm Kelvin Rutledge. The title of this webinar is rather unwieldy: When are resources relevant to whether the court, law and authorities comply with the statutory duty? But the focus of the webinar will be on the recent judgment of the Supreme Court in the case of the London Borough of Croydon against Imam. The question it will be addressing is, what does the judgment mean? And attempting to answer that question, you have the three lawyers before you who represented Croydon in the case. Now, for so long in housing law, the thorny issue of resources, or more usually the lack of them, has been the elephant in the room. This is especially so where courts have been asked to grant mandatory relief, compelling a local authority to comply with its substantive duties under Part 7 of the Housing Act 1996. So often the court has become fixed on the individual circumstances of the case before it and reluctant to turn the telescope round the other way to look at the broader impact that its order might have on other housing applicants, or indeed on the authority's ability to perform its other functions. Traditionally, courts have proceeded on the footing that a lack of resources is a matter for Parliament and not for judges. In Birmingham Airways, the case that endorsed the homeless at home approach to Part 7 performance of duty, the House of Lords did recognise the relevance of resources, but left open the question of the correct approach to mandatory relief. Imam was concerned with that single and very important issue. This webinar will be in three parts, followed, time permitting, by an opportunity for you to ask questions. Please put any questions you have in writing so that Riccardo and Vicky can provide me with the answers. Thank you. Over to Riccardo.
Thank you, Kelvin. Although no doubt many of you already know Imam inside out, and some of you no doubt better than me, I thought it might be helpful to start by outlining what it was about and what happened, which will hopefully give you a good introduction and a platform from which to understand the far better and better delivered talks that you'll hear from Vicky and Kelvin. The judgment is detailed and replete with internal cross-references, and there is lots in it. So I doubt I'll have time for much analysis as I go through it, but as I've said, that's where the other two speakers will skillfully come in. Will, if you could move forwards to the first of my substantive slides. Thank you. So what was the issue? The broadest context was the circumstances in which the admin court may refuse to make a mandatory order compelling a public authority to act in compliance with a statutory duty. And at that level, the content of the Supreme Court's decision is of supreme and far-reaching consequence throughout the public law sphere. The narrower question was, to what extent are the limits of an authority's resources relevant to the question whether a mandatory order should be made? That too is of general importance far beyond housing law. And the specific context was the application of those issues to an authority's admitted breach of the duty contained in section 193 subsection 2 of the Housing Act 1996, although of course the decision applies equally to cases in which the breach has been determined at contested proceedings. This slide shows you how the Supreme Court, or Lord Searle giving the only judgment, characterised the issue. Could I have the next slide, please, Will? The facts: the applicant was a full-time wheelchair user who applied to the Authority for Homelessness Assistance. The authority accepted that she was owed the main housing duty and accommodated her in a property it subsequently found to be unsuitable. The decision maker does not appear to have addressed the question whether the property might be suitable in the short term, even if it was not or could not be in the longer term. It was accommodation on 2 stories with a through-floor lift. The applicant's bedroom was on the first floor, and crucially, for reasons of incontinence, the property did not have a bathroom on the first floor, so that if the need arose during the night, the applicant had to attempt to get downstairs on her through-floor lift. She brought a claim for judicial review, in response to which the local authority admitted that it was in breach of statutory duty, but asserted that no mandatory order should be made because of the severe pressure on its resources. Or put another way, it conceded the claim, but asserted that the applicant should not be afforded any relief in the exercise of the court's discretion. Can I have the next slide, Will? So what happened, as the slide says, in the admin court, the deputy judge refused to make a mandatory order. He noted in particular 8 factors. 1, not having put in any evidence as to the consequences on her, the applicant, of the unsuitability of the property. The court was not in a position to assess the impact that the unsuitable property and its unsuitability had on her. 2, the deputy judge found that the authority was doing all that it reasonably could and could not by mandatory order be compelled to do more. 3, countervailing those first 2 factors, the very fact that the authority was doing all it reasonably could made the need for a mandatory order more pronounced, in that the authority had failed to come up with suitable accommodation. 4, so too did the fact that the applicant had been waiting a very long time for suitable accommodation. And unless I get my chronology wrong, that is 6 years by that time. 5, the authority's finite resources were relevant, this is critical, to the exercise of the court's discretion. 6, so too was the impact of the authority's finite resources, in particular in relation to prioritising the applicant by making a mandatory order. Sorry, Will, can I have the next slide? Thanks. The consequence being that others whose need may have been greater or whose wait longer would be pushed down the waiting list. 7, the authority could not be obliged to buy a property for the applicant. And 8, the authority's evidence was detailed and it showed it to be in an impossible situation. So as I say, no mandatory order. Again, next slide, please, Will. The applicant then appealed to the Court of Appeal, and the paragraphs on the slide there are the 2 particularly relevant paragraphs from the judgment of the Supreme Court, summarising what the Court of Appeal had said. That court allowed her appeal. The deputy judge had been right to say that no order should be made if it was not reasonably possible for the authority to comply, but it found that the deputy judge could not properly have come to that view on the basis of the evidence that the authority had adduced. Lord Justice Lewis, who gave the lead judgment, adopted slightly different wording to the wording that the deputy judge had used. He asked, has the authority taken all reasonable steps to perform the duty? And it's from there that we have the new all reasonable steps test. If so, it may not be appropriate to grant a mandatory order, and if not, it is to be assumed so far that a mandatory order follows. Next slide, please, Will. I said a moment ago that the Court of Appeal allowed the applicant's appeal. So what exactly was the judge's error? He made 2 in the eyes of the Court of Appeal. First, a reference to general budgetary constraints was not a sufficient basis on which the authority could overcome the burden that it faced of convincing the court that no mandatory order should be made on the facts of the particular case. And second, in a similar vein, the authority's evidence had been too general because, rather specifically, it had not shown that it had considered using Part 6 accommodation, usually reserved for allocations, for Part 7 purposes, that is to say, for temporary accommodation. That may have been because until the decision in El Kundi, as this case was then called, authorities were not generally mixing their stock. Part 6 for allocations, Part 7 for TA, for temporary accommodation. And I dare say that many authorities are still adopting that distinction, in response to which I say, beware, and I think, listen closely to what Vicky has to say. Next slide, please, Will. The Court of Appeal's criticism of the deputy judge had not, at least in the Supreme Court's view, gone much further than that. He had been right in five particular ways, or 5 ways in particular. One, he'd been right to note that the property was only barely unsuitable. The submission that had been made before the deputy judge, which he rejected, was that it was 9/10 suitable. 2, the deputy judge had been right to consider the impact of the unsuitability on the applicant, particularly in the absence of any evidence from her as to the effect of the property's unsuitability on her. 3, the length of time, 6 years, for which the applicant had been unsuitably accommodated was material. 4, as was in the authority's favour, the fact that there was only a limited number of satisfactory properties. That is to say, to my mind, that at least some aspect of resources was relevant. And 5, the deputy judge had also been right to find that the authority could not be compelled to acquire a property. Next slide, please, Will. Finally, the parties came before the Supreme Court on the authority's appeal this time against the decision of the Court of Appeal, by which the authority sought to uphold the deputy judge's decision. Its case was in 3 broad parts. First, resources were relevant, so whether to make a mandatory order. Resources were relevant to the court's exercise of its discretion. The fact that an authority had more or less money, more or less stock, more or less staff, had to be factored into the extent of the steps it was required to take and the extent of the obligation that could be imposed upon it. Second, that the Court of Appeal had been wrong to criticise the authority's evidence as being insufficiently specific. And third, that the Court of Appeal had been wrong to suggest that Part 6 stock should be used to satisfy the Part 7 duty. In particular, the authority asserted that imposing that requirement amounted to the court impermissibly entering into questions of allocative discretion, which was a task only the authority, with its democratic mandate and cognizance of its general budget, was qualified to undertake. The applicant retorted in 2 parts that resources were irrelevant to whether to make a mandatory order, except in cases of actual impossibility, and that the Court of Appeal had been wrong to uphold the deputy judge's decision that the authority was not required to buy her a property. Can I have the next slide, please, Will? As I said in opening, the decision of the Supreme Court on these issues is complex, but it is also determinative and of extremely wide application, so it's worth exploring in some detail. Lord Sales gave the only judgment. He started with the general proposition at the top of that slide that resources are irrelevant to compliance with a statutory duty, but immediately tempered that. The ordinary position is that establishing one's claim means that relief should be granted, but it is well established in public law proceedings that remedies are discretionary. That is to say that merely establishing one's claim does not inexorably lead to a conclusion that an order should be made or relief otherwise granted. And then tempering that again, Lord Sales said that the court should not refuse relief routinely and that it should proceed cautiously when it was considering whether to do so. In particular, the court was required to bear in mind that Parliament imposed the duty on the authority and that the effect of the court making a mandatory order was effectively to transpose the role of principal onto the court rather than the authority, with the court thereafter effectively supervising the authority's compliance with what it termed a superadded duty. That was one matter that might militate against the grant of any mandatory order. Another was the risk of detriment to good administration. So, for example, this refers to cases in which decisions have been made or actions taken in reliance on a matter being finalised, only for the court to upset the balance thereby achieved by granting relief, or maybe I should be a little bit more specific. There are various reasons that judicial review claims must be brought within a limited time following the impugned decision, and one of them is that public authorities should not be frozen through the passage of time by the risk of litigation. Another matter that might militate against the grant of any order was the hardship or prejudice that might be caused to third parties. In the context of this claim, that might, for example, be a reference back to the idea that the litigious shouldn't necessarily be allowed to jump the queue above those whose claims might be, for whatever reason, more meritorious. And finally, on resources, the court seems, to me at least, to have adopted a middle way between the authority and the applicant. Impossibility does not mean literal impossibility, but it does require the authority to show that it has taken all reasonable steps, and, which is key, what all reasonable steps might be must be looked at in the context of the authority's existing plans for the allocation of its resources. That was called the DOM point, which should not be disrupted. So resources are relevant, at least in this way. Next slide, please. The Supreme Court held that the Court of Appeal had been right to identify that where a breach was established on admission or by finding, it was for the authority to explain why no order should be made, not for the applicant to explain why it should be. The Court of Appeal had also been right to impose an all reasonable steps test, and the authority's view on whether it had taken such steps is susceptible to challenge on bases wider than just Wednesbury. It was also right to hold that the authority was required to give consideration to using its Part 6 stock, which it has a duty to allocate in accordance with its scheme, but otherwise in respect of which it's subject to powers. Sorry, start that sentence again. The authority was required to give consideration to using its Part 6 stock to satisfy its Part 7 duty. And finally, the Court of Appeal had been right to criticise the authority's evidence as being insufficiently specific. My penultimate slide, please. Well, the applicant cross-appealed in respect of the Deputy Judge and the Court of Appeal's decisions that the authority could not be compelled to buy property. That cross-appeal failed. It could not be compelled to buy the applicant a property. And then my final slide, please. The Supreme Court then went on to list 5 comments that authorities will be expected to pay heed to in defending Imam claims such as the applicant's. First, does it have a contingency fund? And if it does, has it considered employing it to assist the relevant applicant? Second, has there been a history of non-compliance with the main housing duty, presumably relating to the facts in the instant case and beyond? There's a suggestion that there might be an inquiry, which is rather worrying. Third, are the applicant's circumstances particularly dire? Fourth, to what extent has the authority complied with the requirement to take all reasonable steps? The better its attempts, the less likely an order will be made. And fifth, a repetition of the point I made earlier, caution should be paid to promoting the litigious above those whose claims are more meritorious, and any witness statement in an Imam claim will be expected to deal with those matters. That is the end of my part of the talk, and I happily hand you over.
Thanks, Riccardo. Some have teased me for my submission I made to the Deputy Judge, but not adopted by him, that the accommodation questionnaire was, quote, 9/10 suitable. I've not used it since then. So in this second part of the webinar, I want to look briefly at 5 points arising from the single judgment of the Supreme Court. No doubt there would be more when legal analysts have had sufficient time for reflection of this important judgment. But just to summarize the points that I'm going to talk about, there's first the immediacy of the main housing duty. Secondly, the threshold for suitability. Thirdly, when performance is impossible. Fourthly, a warning of the added effects of mandatory relief. And finally, the question of balance. Next slide, please, Will. So let's look at the first of those points. And the headline is that the Supreme Court did not unreservedly endorse El Kundi on the immediacy of the main duty. Now, as you probably know, in the Birmingham and El Kundi case, which was heard with Imam in the Court of Appeal, but in that case, at first instance, Mrs. Justice Steen had found that the main housing duty is a duty which is immediate, unqualified, and undeferrable. And that's a view with which the Court of Appeal in El Kundi agreed. And it's right to say that the Supreme Court in Imam doubted that approach. If we look at paragraph 38, it says that this is Lord Sales in the Supreme Court giving the single judgment. Lord Justice Lewis considered that suitable accommodation is to be available from the time when the duty is owed. I reserve my opinion whether that way of putting it is exactly right. As I've said, we did not hear submissions on that point. Pausing there, as Riccardo has said, it was Croydon's position throughout the litigation that the duty was owed. So the El Kundi point didn't arise, at least not head on. But Lord Sales continues that it is clear that the duty is directed towards achieving an end result, the provision of suitable accommodation. And even if some time is required for consideration how ultimately to achieve this, it would be implicit that the end result would have to be achieved within a reasonable time. Now, there are cases on the Housing Act 1985, Part 3, the predecessor to Part 7 of the 1996 Act, which are consistent with the approach that the duty, properly understood, is one to achieve a result within a reasonable time. This is not part of the essential reasoning of the Supreme Court's judgment. And as I say, it's not an issue that arose at least directly for determination. But I would suggest that powerful reasoning that the duty under 193, properly understood, is a duty to provide a particular result within a reasonable time, the reasonableness of which will obviously vary on a case-by-case basis. And it's interesting to note, as a postscript, that the editors of Westlaw consider that this passage, paragraph 38, casts some doubt on the ratio of Mrs. Justice Steen and the Court of Appeal in the El Kundi case. So, a bit of a shame really that Birmingham didn't appeal to the Supreme Court alongside Croydon, because the indication is if they had and put into full focus the immediacy of the duty, they may well have done better than they did in the Court of Appeal. Next slide, please, Will. Thanks. It's well established that local authorities may discharge their Part 7 duty in stages. In the El Kundi case I've mentioned, it was considered by the Court of Appeal and also by Mrs. Justice Steen that resources are relevant to the level of suitability that can be achieved, certainly in the short term, such that a local authority could rationally decide that due to a lack of resources, accommodation may be suitable for the short term, even though it would not suit the applicant for the longer term. So to that extent, both courts decided that resources were relevant, and the Supreme Court endorsed that view. So looking at the question of suitability, it might be an answer to a suitability challenge that due to a lack of accommodation, the accommodation being provided is the best that can be achieved for the time being. Now, of course, accommodation must, under the statute, always be suitable, but I think it seems clear that Imam has lowered the bar in that respect. Next slide, please, Will. The third point is about impossibility. Riccardo's already mentioned this. Whether it's impossible for the local authority to perform its duty is a question that has to be considered in the real world. Riccardo mentioned the Dom point. That was a case on which Croydon relied in the Supreme Court, Royal Borough of Kensington Chelsea against Dom, that the court has to work from the de facto position where budgets have already been set and not be able to go behind those. And that point, I think, comes through quite forcibly in the judgment of Lord Searle. But this question of impossibility is an important one. Public law has recognised for well over 100 years that a mandatory order may be refused where performance of the duty is impossible. But previous case law has defined impossibility quite strictly as being limited to legal or physical impossibility. But it's clear that Imam has changed the law in that respect, and it now extends to practical impossibility. So, and I think that comes through very clearly in these passages 61 and 62 that are put up on the screen for you now. So it can be said on the basis of this judgment that once the local authority has set its budget and decided how it's to spend its money, the court must respect that decision and not make an order that will force it to divert funds earmarked for other purposes. And that's perhaps overstating the principle, because ultimately, as we will see, that principle has to be balanced against the fact that Parliament has put in place a duty. But this point of deference is a very strong theme running through the judgment. Next slide, please, Will. Key point 4, recognition that mandatory relief may produce unreasonable results. Again, Riccardo alluded to this, the reference to the superadded force of a mandatory order. A major limb of Croydon's argument before the Supreme Court is that if the court ignores resources, then the law would favour the litigant. The first applicant before the judge gets the prize, irrespective of that applicant's priority vis-a-vis other housing applicants. And Croydon's case, and I think it's important to understand this, Croydon's case was that properly construed, the main housing duty is not a duty that is to be exercised in a factual vacuum, but rather it is a duty that has to be exercised having regard to all other applicants, at least all other Part 7 applicants, so that a local authority, which, for example, decided to channel all its available resources into providing the most luxurious accommodation for one applicant, prima facie acts unlawfully. So it's a special kind of duty. And I think there are clear indications in the judgment that the Supreme Court accepted that as a general approach. Paragraph 45, where a court issues a mandatory order, that order produces legal consequences of its own over and above those inherent in the underlying statutory duty. And further on, the court should consider whether it is right to create those additional effects in all the circumstances of the case as it presents itself to the court. So the point is that a mandatory order, if the court isn't careful, the mandatory order will put the claimant in a far stronger position than she or he would be under the duty imposed by Parliament. And that's a real risk. As I say, if the court isn't careful, it will end up making an order which favours the particular litigant and disadvantages all those who are not before the court. So again, it's looking once again at the wider impact of the mandatory order, which is amongst the strongest of the court's armoury. Next slide, please, Will. And my fifth point is this repeated theme running throughout the judgment of the attempt to reconcile, essentially the tension behind this case was, on the one hand, Parliament having put in place a duty to accommodate those owed the main housing duty. Parliament could have given local authorities a power to do it, but it decided back in 1977 to impose a duty, albeit one that is arguably not a duty, as Mrs. Justice Stein explained, to be performed immediately and in an unqualified way, but perhaps within a reasonable time. But on the one hand, there is this duty. And on the other hand, the practical reality that the local authority may not have the ability, the resources to perform not only its immediate duties, but also its wider duties. So it's not just Part 7, it's not just housing, it could be other duties to children, vulnerable persons, adults, mental health patients, and the rest. Everyone there potentially has a call on accommodation. So I think that's very helpful. I mean, obviously the Supreme Court doesn't answer the question, how does the court strike the balance? Because of course that's something that has to be worked out in the fullness of time on a case-by-case basis. But at least it's at last it's a recognition that resources are a vitally important consideration, as important, at least potentially as important, if not more, than the substantive duty itself. So those are key points. As I say, I'm sure on further reflection and consideration, other points will arise. Thanks. Over to you now, Vicky.
Thanks, Kelvin. Hi, everybody. I'm going to take a bit of a step back from the judgment itself and look at some of the practical issues that arise from the judgment. And if I can have the next slide, Will, please. Thank you. So I've structured this part of the presentation around the questions that I've been asked most frequently since the judgment was handed down. And in fact, since we were in the Court of Appeal and the Al-Kundi judgment was handed down as well. So kind of in summary, and we'll take them in order, must I use Part 6 stock to perform Part 7 duties? Must I acquire more stock if I cannot perform a Part 7 duty? Do I need a Part 7 allocation policy, or indeed other policies? When and how should I escalate complex cases within my authority? And the crunch question, I suppose, how do I avoid a mandatory order? And I suspect we won't necessarily know the answer to that last one until we see some further litigation over this in the lower courts. Next slide, please, Will. So starting then with balancing Part 6 allocations and Part 7 duties. Part 7 of the Act imposes hard duties on local authorities. Those do range from a duty to provide advice to prevent homelessness at the lower end of the scale, up to the main housing duty that is owed to those who are homeless, eligible for assistance, in priority needs, and who did not become homeless intentionally at the top end of the scale. Where that main housing duty is owed, an authority must secure that accommodation is available for occupation by the applicant and by anyone who usually resides with them. In contrast, Part 6 of the Act is concerned with the allocation of housing on a secure but non-temporary basis. Local authorities allocate accommodation by granting secure tenancies over their own stock, or by nominating people to assured tenancies with social landlords. While local authorities must have an allocation scheme for determining priorities and the procedure to be followed in allocating accommodation, they aren't specifically obliged to hold any stock or to make any allocations, although in the event that they do allocate, they must do so in accordance with their scheme. So when you look and contrast those two parts of the Act, it becomes quite clear why the court held that allocation under Part 7 is a matter of binding legal obligation, whereas assigning properties for allocation under Part 6 is really a matter of discretion. So as Riccardo explained a moment ago, the Supreme Court ultimately held that authorities do need to prioritise their existing stock to meet those binding legal duties under Part 7. And that potentially means that accommodation needs to be prioritised for Part 7 over Part 6. But I don't think that necessarily means that all existing stock must be used for the purpose of performing Part 7 duties. So there are plenty of circumstances in which you may well lawfully not use your existing stock to meet a Part 7 duty, particularly where you can perform your duty to that applicant in some other way. So you may continue to secure accommodation, for example, by procuring nightly let accommodation, such as hotel or bed and breakfast accommodation. Such accommodation will be suitable for many of the people who apply to you as homeless, and it may well be suitable for an even larger cohort of applicants as emergency accommodation or in the short term. And you can, of course, continue to secure accommodation in the private rented sector as a means of ending the main housing duty. So this balance and this issue of Part 7 versus Part 6, I think, really bites where you are in a position where you've considered those options and other options available to you, but you remain unable to perform a Part 7 duty owed to a homeless applicant. I think in those circumstances, you must consider whether to use a property that's available from within your own stock to perform your Part 7 duty. It's important to bear in mind that doesn't mean that you should make a Part 6 allocation unless the homeless person you're dealing with is properly the next person on your waiting list for an allocation under your Part 6 scheme. If you allocate out with your allocation scheme, you are, of course, then at risk of judicial review challenge to that, as that is a breach of the statutory duty to allocate only in accordance with your scheme. So instead, the solution that Lord Lewis came up with initially in the Court of Appeal, and which the Supreme Court subsequently appeared to ratify, was the granting of non-secure tenancies over Part 6 stock, or stock that it's at least been assigned for Part 6 purposes, as a way of circumventing that restriction on allocations. So, as I say, in some cases, there may be a range of options available to you, and you should feel free to explore those options where you have, for example, a single applicant with no dependents, with no specific physical or mental impairments that necessitate adapted, supported, or other specialist accommodation. You may well elect to secure hotel or bed and breakfast accommodation for them so that you can keep stock back for allocation under Part 6 purposes, which is usually most authorities' preference. However, in those cases where you know that those other options are going to be limited, or where the availability of stock on a nightly let basis or in the private rented sector is not going to meet a complex housing needs, I think in those circumstances, you must consider taking a property from your Part 6 stock to perform your duty. I think it's going to take time to see how that works through in practice. I fear that there will inevitably be some unintended and undesirable consequences. I think Over time, we will see more of a council's own stock being used for Part 7 applicants, and that will have the consequence of making it more difficult to end Part 7 duties by making Part 6 allocations. I'm not sure there's an easy solution to that, and I suspect that in reality, only legislative reform or a significant injection of funding will ultimately resolve the issue. But I think the Supreme Court have made absolutely clear the legal position, and I think that's something that local authorities need to pay very careful regard to when they return to their authorities. Next slide, please, Will. So if you can't perform your duty and you've considered your own stock, but still don't have anything available that you think could be justified as suitable, do you have to buy or adapt a property instead? As Riccardo and Kelvin have both explained, the Supreme Court was quite clear that you don't. The main housing duty does not require you to divert resources from other service areas or to borrow more to procure a suitable property. Generally, the courts won't look behind budget decisions that you've already taken, as the courts recognise that they lack the democratic authority and institutional competence to do so. That means you aren't required to reallocate funds from other service areas or from other budget heads once your annual budget has been set. However, the Supreme Court was quite clear that you should have regard to using contingency funds that you might hold, either within your housing service or across the council, to consider whether there is a way to perform your Part 7 duty. If you have some form of contingency within your budget, either within the service or for the full council, the court may expect you to dip into that contingency to procure a property. So that's something you need to think about. Equally, where breaches have endured for a significant amount of time, which is increasingly becoming the case as the balance between demand and supply of social housing tips even further into difficulty, the courts may well inquire why provision hasn't been made in your budget to meet a Part 7 duty. And as you move from one budget year into the next, you should be actively raising these complex cases, making your senior officers aware of potential breaches or enduring breaches that need remedial action, so that that can be considered through the budget setting process as you move into the next financial year. Next slide, please. So I spoke a moment ago about how you might balance your existing housing stock as between Part 6 and Part 7 applicants. I think that balancing act is going to be incredibly difficult for local authorities, and I think it's likely to come under increasing scrutiny as further cases come before the courts post-Imam. Some authorities already publish policies on how they assign their existing stock for different purposes, primarily between Part 6 and 7, but not exclusively. However, I think a majority of local authorities do tend to rely on their allocation scheme and don't have a policy or publish a policy that in effect sits above that allocation scheme and deals with the assigning of properties as between Part 6 and other uses. So I would strongly recommend that you give careful consideration to adopting such a policy. It will help you to manage your stock and the many competing demands on that stock, but it will also help you to evidence the fact that you do actively consider using all available properties to perform your Part 7 duties, including those that could be used instead under Part 6. And it may also help you to show why it might not be appropriate to use a property from your Part 6 stock to perform a Part 7 duty in a particular case. If you do decide to adopt such a policy, I think it's important, as Kelvin was saying, that you consider all of the potential claims that you receive for accommodation. So that's not just claims under the Housing Act. It also includes people to whom you might owe duties under the Care Act, the Children's Act, or rights that people assert under the Human Rights Act for accommodation support. I think most authorities do now have some form of Part 7 policy that explains how they will allocate accommodation as between applicants with competing Part 7 claims. I think as the battle and the challenge to meet all of the duties owed to all people who present as homeless becomes more difficult, how you reconcile those competing claims as between people owed the same or competing duties will be increasingly scrutinised. So I've listed on the screen some of the factors that a Part 7 policy should consider. I'm not going to read them all now for the purposes of time. I suppose the one thing I would say is that I think any policy should afford the authority a considerable degree of discretion, so that decisions in the really complex, knotty cases that are the most difficult to resolve can be taken in the light of all of the circumstances, and taking into account not only the needs of the individual applicant before you, but also the competing rights of all of those who may have an equal or better claim. Next slide, please, Will. Thank you. I think one area that's often overlooked when we talk about how to minimise JR risk and minimise legal risk is an authority's own internal governance arrangements. I think too often, as an external solicitor coming in quite often once proceedings are issued, it seems that in-house legal teams, senior officials, elected members only become involved in cases once litigation is commenced, but by then it's almost certainly too late. So I'd ask you to think about whether your authority has clear governance and structures in place, whether your officers know when to escalate high-risk cases and who to, whether you involve your statutory officers or elected members in cases of breach or where there's a risk of litigation. It's important to bear in mind that the longer a breach continues, the more likely litigation becomes. But the Supreme Court also made clear that the passage of time is a factor when deciding whether to grant mandatory relief. I would strongly encourage officers to raise difficult cases immediately. It will very often be clear when an applicant first presents as homeless, or when you first assess their housing needs, that the accommodation they need is of a type that's in extremely short supply. Once it becomes clear that the authority is going to breach its duty or has breached its duty, I would suggest that the monitoring officer is informed. The monitoring officer should be cited on all breaches of any legal obligation, and they will be able to take appropriate steps to help mitigate that risk. And as I mentioned before, as part of the budget setting process, it's obviously important to involve the lead member or cabinet member, your Section 151 officer, and potentially the head of service, so that provision can be made in your budget to deal with those complex cases. Just on to the next slide. I'm conscious time's quite tight today, so I've included a few kind of summary points and hints and tips to take away. First of all, on a case-by-case basis, and then perhaps looking a little bit more strategically at how your authority operates. So as I've been saying, complex cases should be identified and escalated immediately. In those cases where you identify that meeting an accommodation need will be difficult, your usual allocation policies may well not yield a suitable property. So you might need to think about taking a more proactive approach to searching for suitable accommodation. You might need to think about more creative solutions than simply waiting for a property to become available that you can allocate. You must ensure that you're considering the entire pool of available properties, even if you suspect the particular type of accommodation may not be suitable. You'll need to work collaboratively within your authority and between authorities. I think authorities can frequently become siloed, and this can be a barrier to exploring all available options to meet a Part 7 duty. If you need to consider granting a non-secure tenancy over a Part 6 property to meet a Part 7 need, that's likely to require a number of different teams to work together collaboratively to find a solution. I wouldn't be a lawyer if I didn't tell you to keep records, and keep records of everything, even if they're only really brief. If you've considered a property and immediately discounted it on the basis of suitability, just pop a short file note on your housing record. It doesn't need to be long. It could literally be a couple of a couple of sentences. Better still, use those file notes to update applicants on the steps that you're taking. So many litigants complain about lack of communication or about too few updates on their cases as they go. You'd be surprised how far periodic emails just updating on the situation can go to mitigating litigation risk. So on the next slide, please, Will. Final slide. So just looking at a slightly more strategic level then, I'd ask you to think about how you can leverage some of your other powers and functions to increase your supply, particularly your planning powers, but also the nominations agreements you might have with registered providers. There are ways in which you can use your other functions and other powers to increase the pipeline of supply of social housing in your area. I suppose on the other side of that demand and supply balance, your homelessness strategies and your approach to homelessness prevention will be critical as you try to reduce or at least slow the rate of increase in the numbers of people presenting as homeless. As I mentioned before, you need to think about your governance structures, your plans and policies, and I think crucially, how you work to cultivate a culture in which risk is discussed openly and honestly, and officers feel able to raise concerns about difficult cases at the right time. I'm conscious we've only got about 10 minutes left, so I'm going to hand back to Riccardo now to pick up some of the questions that might have been popping up in the chat.
Thanks, Vicky. Excellent stuff. Yeah, we have had some questions. I think there may have been one or two hands raised. Can I ask you, please, if you do have a question, and we're conscious of the fact that you will have other commitments to get off to, so we'll try and finish on time if we can. But if you do have questions, if you could write them down. One delegate did that, and on the question of consultation, which I think, Riccardo, you have answered.
Yes. I hope to the delegate's satisfaction.
I'll just share the answer with us.
Oh, I see. That's very kind, Kelvin. So I've answered two questions in the panel. I was answering a third. The first question was, can the principles in this case be carried across into adult community care? And the answer that I gave to that was, insofar as the substance of the decision relates to the circumstances in which a mandatory order may be made by the admin court compelling compliance with a statutory duty, it's of general application. So yes, in principle, the principles can be carried across into the entirety of the public law sphere. And the second question I was asked, or we were asked, was about the duty to consult secure tenants. And I hope the box stopped me typing. I could have gone on forever, but the answer that I've given, which I hope is helpful to whoever anonymous attendee too is, was that the specific issue the Supreme Court and the Court of Appeal in its turn were looking at was the performance of the Part 7 duty by the use of Part 6 accommodation, not the discharge of the Part 7 duty by Part 6 accommodation. So it wasn't saying when you owe someone the 1932 duty, you must bump that person up your waiting list. You must allocate out with your allocation scheme. It was saying you must give consideration to using void property, vacant property, that you would otherwise throw back into your Part 6 pool and allocate in accordance with your allocation scheme. You must give consideration to using that property temporarily to perform your Part 7 duty. So it's a very particular kind of use that's being proposed, and because it's that particular type of use, it's a non-secure tenancy within the meaning of Schedule 1, Paragraph 4 of the Housing Act 1985. So allocation scheme and the issues that arise thereunder don't arise. If the question is, do I need to consult under Section 105, which I think it must be, Section 105 talks about the management of dwelling houses let by the authority under secure tenancies, and the particular property won't be let under a secure tenancy. Mohammed, thank you for your question. Will, who's the person seamlessly organising this webinar, will be sending slides, I think, to everyone who's signed up. Kelvin, I think you wanted to give a view on one of these, on the top question.
But there was a question about whether the if a local authority wants to use Part 6 stock to fulfil a Part 7 duty, which was the line that Lord Justice Lewis took in the Court of Appeal, should it do so by means of a non-secure tenancy? Well, the answer to that is yes, it almost certainly has to, because otherwise it would constitute an allocation under Section 159 of the Act, which cannot be made except in accordance with the scheme. So that was Lord Justice Lewis's rather neat way around the problem that you can't dip into your Part 6 stock without colliding with your published scheme. And that is a difficult question. Vicky's spoken about that, and that one I think will have to be worked out in the fullness of time. We've had another very interesting question about the democratic legitimacy of a Part 6 allocation scheme, which does not hand over all its accommodation for Part 7 duties. So I think ultimately the answer may be, as Lord Searle says, a question of balance. But as I say, these are very difficult questions that need to be worked out. And the reason they now need to be worked out is because for the first time in 40 odd years of homelessness legislation, the courts are now forced to address the question of resources. Now, I note that it's coming up to the hour. Riccardo, Vicky, there's anything else you want to say, or that you feel that we might be able to squeeze another question in?
I see Karen's question. Karen, I think the answer to your question might, I'm afraid, be what Kelvin's just said in closing in answer to the previous question, which is that the test is all reasonable steps until the High Court at first instance in a judicial review claim and or the Court of Appeal on appeal tells us what the Supreme Court means. The answer is unclear. We'll have to work it out, I'm afraid. I can't give you a more concrete answer at this stage.
I was just looking at Simon's question. So Simon asks, in effect, if you do use a property from your Part 6 stock to discharge a Part 7 duty, how long does that continue? And is there a specific time frame that's generally accepted when that arrangement might come to an end? And I think that really goes to the heart of the difficulties that arise from what the court have said about prioritising stock for Part 7 purposes over Part 6, because if you allocate a property from your stock to perform a main housing duty on a non-secure tenancy, you perform that duty and you discharge that duty, but you don't end it. That Part 7 duty owed to the person who has the benefit of that non-secure tenancy will continue until such time as you can lawfully end the Part 7 duty in one of the ways set out in the Act. So effectively, a Part 6 allocation of property from your own stock, nominating as a tenant to a property held by a social landlord on a secure tenancy, or a private rented sector offer. Now, as more stock ultimately gets used to perform Part 7 duties and those Part 7 applicants remain effectively stuck there, unable to secure a Part 6 allocation, then that will increasingly, I think, remove stock from the Part 6 pool and leave more stock tied up effectively as being used on a non-secure basis, and applicants under Part 7 could remain there for many years waiting for a permanent solution. So I think that's where I mentioned in my presentation, I think there will inevitably have to be either a review of funding or some form of legislative reform, because I don't think that position will be able to endure for years and years without some action to resolve the situation.
Thanks, Vicky. If I could just squeeze in one further comment. I see that Robin Levitt has asked a perceptive question, or rather, I think, made a point that in practice, once a Part 6 property is let to meet a Part 7 duty, it would never return to the Part 6 pool. And I think we can all understand that that's a real risk. I suppose, in fact, I think that was a theme that was discussed during the course of the two hearings. I think that's probably right. But again, it's something we need to work out in the fullness of time. It may be that the property will remain a non-secure whilst that applicant awaits their turn in the Part 6 list, at which time, when they get to the front of the queue, then you can convert the non-secure into secure. Whether that's the answer, I don't know. Anyway, we have now run out of time. Thank you very much indeed for your attendance. This is a difficult area, but it's a developing area, and I think it's developed substantially as a result of the Imam case, which has put resources firmly on the agenda. It requires the court now to look at the wider picture, and it warns the court about the superadded force of mandatory relief. And it also tells the court that no longer can it direct the local authority to go away and obtain bespoke accommodation for the claimant. So all those points have, I think, been achieved. Thank you very much indeed for your attendance, and thank you, Riccardo and Vicky, for your contributions, and good afternoon.
And I'm pleased to say I've finally finished typing the answer to the last of the panel questions. Good afternoon.
Thanks, everyone. Bye.